Assalamu alaikum everyone. This is Nadia Khadam and welcome to the Big Podcast. Today we are here to discuss the ADR initiatives and developments in Pakistan over the last few years. And for that discussion, we are pleased to have Dr. Chitlik with us. She is licensed international attorney, litigator, and registered mediator. She served as a foreign specialist for U.S. Department of State. She currently works as a U.S. Department of State Fulbright Specialist and senior fellow at the Center for Law and Religion at Emory University. Together with her graduate team, they created a Fulbright ADR pilot program under the affiliate of Global Learning Online, whose mission is to focus on education as a human right. And Dr. Jo is working closely and observing the ADR initiatives and developments in Pakistan over the last few years. So welcome, Dr. Jo.
Thank you so much for
Welcome
having
to
me.
Pakistan.
Thank you. I appreciate it so much. I'm so excited to be here at Beaconhouse International College. Thank you.
So, as I mentioned, that you are closely observing and working with some of the initiatives and related to ADR. So, would you agree that ADR, Alternate Dispute Resolution, which is commonly known as ADR, is having its moment currently in Pakistan?
Yes, I would completely agree with that. Pakistan is living what I like to call Pakistan's ADR renaissance. ADR is something that is new to Pakistan. As a matter of fact, it's something that is very ingrained in the culture and history of the Islamic country of Pakistan because it has its roots in Islam. What is different today is that Pakistan is living a reawakening of ADR, and it is doing a focus on elaborating it and expanding it into its judiciary so that it becomes more mainstream.
So when we look that ADR is not a new thing even in Pakistan, but how you think that this time, which we call it a momentum in Pakistan for the ADR, is different from the past?
Well, in the past, mostly in about 2018, when Pakistan tried to roll out ADR, one of the things that Pakistan did differently now that they didn't do then is they didn't get the buy-in of the judiciary. And that's extremely important in my experience. You see in Pakistan today how the Supreme Court of Pakistan has embraced under the leadership of Justice Shah, there's a series of judgments that play an important role in the development of ADR within the courts. You also see the High Court, specifically the Court of Lahore, where they are embracing what is known as court-mandated mediation. And the fact that you have the buy-in of the judges makes it very different because they are the ones that are proposing a restructuring of the way that litigation is, or the court systems are addressing litigation.
You mentioned getting the buy-in from the greater legal community. For example, the practitioners, which you mentioned. So can you elaborate more about it?
Yes, this is very important. So the buy-in is the concept where you try to involve everybody that is a stakeholder in the process. So this is very important because you cannot, when you're making such a big change in society, you cannot simply roll it out and expect that people are just going to accept it. You have to show value. So one of the things that I find very important for ADR is when you are able to take each one of the stakeholders, and for example, you mentioned the practitioners, and show them the value of adopting ADR into their practice. The practitioners, one of the things that I like to talk about, and I call it what's in it for me. And the reason I call it what's in it for me, it's because it is important as a litigator myself. When we were moving into ADR, it was very important for me to see how that would affect my bottom line in a law firm's atmosphere. When I was able to understand that ADR is not only the resolution of conflict, but it makes the practice of the law much more organized, because you're able to classify your cases within a law firm so that you are able to go ahead and use ADR for those that are ripe for for mediation, but then you also understand clearly those that should proceed on the track of litigation. And that frees a lot of time. So basically, you're getting time back. You know, in America, one of the biggest commodities for attorneys is time. You know, we are segmented in minutes, billable time. And so the fact that we were able to see that we were getting back time that was spent in litigious processes, and these could be resolved so much quicker, gave us the opportunity to get more volume in our law firms, which increased our bottom line.
Okay, we talked about the practitioners, but if we talk about the clients and the effect of ADR on the clients, what are your thoughts about it?
So that's a great point. Okay, so we've talked about basically the judges and we've talked about the practitioners, but let's not forget the most important component of this equation, which is the clients. You know, it's very important that we get some real good clarity regarding how a client feels. So when clients go to litigation, they don't feel the same way attorneys do. A client is usually very apprehensive about litigation. They're nervous, they're emotional, they're angry. All sorts of emotions go through the mind and through the body of a client that's going through litigation. We don't see it the same way as attorney litigants because we get used to it. And for us, it's very common. And I, for instance, can tell you from my own experience that going into a courtroom for me is the greatest thing that ever happened. But this is not the feeling that my clients have. So part of what clients say to you is, I feel like I've lost control. I am no longer in control. Things are happening. I'm going to litigation and I'm no longer in control. Mediation, by introducing mediation to a client, you're basically giving them back what they thought they lost, which is that control. So a client that goes through mediation and has results that are positive is going to be much more inclined moving forward because they have control over their process. Now, another phenomenon that's very important to add to that is the phenomenon of how clients act when they're in mediation. There are clients that if you take them to litigation, they will not budge. They want their position and they will not budge from that position. If you take them to mediation, because it's a more relaxed atmosphere, you can get settlements that you would normally not get in a court of law because people are willing to talk to each other and resolve the matter. So mediation has a lot of positive spiritual and community benefits because of the way that you can interact in mediation.
We talked about the effects on the clients, but in this whole process, mediators is a very important role which that person is playing. So how you see that, how does a mediator's knowledge impact the ADR process?
You make an excellent question. So we talked about the judges, we talked about the litigants, we talked about the clients. Now let's talk about the mediators. I have a very strong position on that. And as a registered mediator myself, I am highly trained in the area of mediation, and I find that it was extremely necessary. There is a general concept at times that because I am able to go to the market and haggle prices in the market, or somebody calls me up and wants me to resolve a matter, that makes me naturally a mediator. It does not make you a mediator. A mediator needs to know and understand the law. And a highly trained mediator is the only person that actually can be beneficial in the process of mediation. So one of the things that is important as Pakistan moves forward is to make sure that they don't only adopt mediation, but that they train the people adequately so that when they get to the court mandated mediations, these mediations can effectively have positive results. It's granted, in mediation, you are not obligated to settle, but that's the goal. The goal is to settle, and to be able to move away from litigation. And you can only move away from litigation if you have a mediator that's qualified and knows how to conduct properly a mediation.
That's very insightful. But as you mentioned that you have experience of your incorporation of ADR in United States, can you tell us more about it?
Yes. So about 2 decades ago, the United States, it's no surprise to anybody when I say to you that we are a very litigious country. We are a country that where litigation is very easy accessible. About 2 decades ago, we started as individual states to look at this closer, and not only for backlog purposes like they're doing in Pakistan, but for a better case management process. And when we started to look at this, we started to visualize what it would be to make 2 avenues where we could basically take certain types of conflicts and submit them to mediation so that they can be disposed of very quickly. And one of the things that we found by doing this is that we were able to take a lot of the smaller conflicts that did not need to be in a court, and we could go ahead and still produce a resolution for them or a settlement for them, but we could leave the bigger items, the bigger cases, the more substantial cases for those to move on to litigation. And I think that one of the things by incorporating it and creating institutions that are tied to the courts, we have adopted a mindset where in the United States, mediation at a court level is very common now. Nobody is surprised to go to a court of law and have a judge say to you, have the parties spoken among themselves? Would you be willing to go to mediation? And most 9 out of 10 times, you're going to have parties and attorneys respond, we are willing to try a negotiation or a mediation. There is a culture tied to it. And a lot of things, a high percentage of cases in the United States now get resolved prior to going to trial.
Yes, that's very wonderful, but I think this is leading to some of the concept which we usually, and you also refer to that, is revamping the courts for the ADR. Mm-hmm. So what is that we can call it in the practical sense, how we can?
I talked about the fact that we can't just roll out mediation. There is an entire legal structure that needs to be adopted. It would be very irresponsible to just train a bunch of mediators and roll out mediation without doing all the necessary components. So I think one of the biggest things that was very positive was that we restructured our courts. And we restructured our courts to be courts that house also ADR. So it's important that we understand that when you talk about incorporating ADR into any legal system, you have a case management system that supports the use of ADR. You have courts with structures that support ADR. Most recently, I read a judgment out of Singh, where a judge speaks about the importance of reorganizing courts altogether so that there can be judges who specialize in specific areas of the law. For example, commercial law, which is one of the areas where we use a lot of mediation, so that the courts can handle these type of disputes and effectively dispose of them through ADR. So I think that as Pakistan moves forward, they really have to think about a cohesive approach to ADR.
We talked about the main stakeholders on this ADR process, and one of that which talked about the mediators and the training and the performed role is very much important, and we talked about it. And for that, I think trainings are very much important. So you are upcoming. You have an upcoming class at Beaconhouse College. So can you tell us about that?
Yes, I'm very excited. So as you were so kind to introduce A part of this Fulbright program was the creation of a pilot ADR program that we were going to launch in universities in Pakistan. We have created through our affiliate, Global Learning Online, a program that is multifaceted. It has a component which is online and a component which is in person, which I teach. And what we've done is that we have taken this project and we've reduced it to the areas of ADR that are most commonly being used here in Pakistan. So I will be teaching in Beaconhouse on foundation of ADR, and then I will move on to negotiation, which for me, as a former negotiator for the United States, is very, very important to develop these skills. And then thirdly, we will be moving on to teaching about incorporating all this into the actual process of mediation. So I'm super excited to be with the students and to be able to convey this knowledge to them and really get them excited about talking about ADR for their future.
And I'm sure with bringing a lot of knowledge and a lot of experience will give a new learning experience for the students in this course. We have a very wonderful discussion, but to close this podcast, I just want to ask you that what is your outlook in Pakistan with regard to Pakistan in the area of ADR?
So I am extremely excited for Pakistan. I see a lot happening in the legal landscape. I appreciate very much that Pakistan is doing this, adhering to the rule of law, and really wanting to cement themselves, not only in Pakistan, but on the world stage. So I see if Pakistan continues to move forward, I see Pakistan not only making a name for themselves regionally, but globally. I think that Pakistan can be a very important contributor to ADR within the Muslim countries, and this is very exciting. I feel like I am living history in the making, and this is very exciting because it's a rare opportunity that not everybody gets in their lifetime. So to just be a very small part and give putting an ounce of a grain into this huge pot it makes me very happy to be part of it and to use my talents for such a time.
Thank you for your time, Dr. Cho. And I want to close this podcast with the two conclusions. One, firstly, to thank you and for your expertise to bringing it all the way from US to us and working with us and giving us so insightful experiences to share with to improve all the systems. Secondly, we wish Pakistan to improve the ADR mechanisms to transform the justice system in Pakistan. Thank you, everyone.